In 45 seconds, a woman who had looked me directly in the eye and lied about her husband, lied about her marriage, lied about a man who had given her 17 years of his life, watched that lie disintegrate in front of every person in that courtroom. I have been on this bench for 38 years. I have seen deception in every form it takes. The well-rehearsed kind, the desperate kind, the kind that almost sounds like truth. What I saw that Tuesday morning was something else entirely. Her name was Donna Hartwell. She arrived in my courtroom that morning in a cream-colored blazer and $340 Anne Klein pumps, flanked by a family law attorney who charged $450 an hour and had a reputation for making inconvenient facts disappear. She was suing her husband of 17 years, a quiet, careful man named Raymond Hartwell, for exclusive rights to their home, sole custody of their 2 daughters, and $4,200 a month in spousal support. Her claim? That Raymond had been emotionally absent, financially irresponsible, a poor husband, and an inadequate father. Raymond sat across from her at the plaintiff's table with a manila folder on his lap and his hands folded on top of it. He was wearing a jacket that was 3 years old. I noticed the cuffs. He had asked for nothing except the truth. That folder is the reason this case is still talked about. And if you stay with me through what happened next, I promise you, by the time you hear what Raymond placed on that courtroom table, you will understand why I went quiet for 11 full seconds before I delivered my ruling. If you have been watching this channel for any length of time, you know that less than 5% of the people watching right now are subscribed. If justice matters to you, if you believe that ordinary people deserve to be heard, take 3 seconds and hit that subscribe button, because this community is built on exactly the kind of story you are about to witness. Now let me take you back to where this really started. Raymond Arturo Hartwell was 51 years old when he walked into my courtroom. He was born in Wheeling, West Virginia, to a steelworker father and a mother who cleaned offices downtown 3 nights a week to keep the lights on. He put himself through 2 years of community college working nights at a shipping dock. He joined the United States Army at 22 years old. He served 2 tours in Iraq, the first in 2003, the second in 2006. He was awarded the Army Commendation Medal and the Combat Infantryman Badge. He came home both times with his life, his faith, and a quietness that some people mistook for weakness. It was not weakness. After his service, Raymond trained as an electrician. He built a career slowly, carefully, the way he did everything. By the time he was 34, he had his own small contracting business, 3 employees, mostly residential work in suburban Cincinnati. He was known in his community for something specific. He never overcharged a senior citizen, not once. Every Saturday morning for 11 years, Raymond drove a 2009 Dodge Ram with 194,000 miles on it to the home of an 84-year-old widow named Mrs. Eloise Pruitt, a woman his daughters called Grandma Pruitt, though she was no relation, and he checked her electrical panel, her smoke detectors, and her carbon monoxide alarms. He never charged her. He never mentioned it to anyone. He never asked for recognition, never brought it up in conversation, never used it to explain who he was. He just went. Every Saturday, for 11 years. I found out about Mrs. Pruitt not from Raymond, but from a handwritten letter she mailed to my courthouse, addressed simply to the judge on TV. She didn't know my name. She just knew that Raymond needed someone to speak for him. She had written 3 pages in pencil. Her handwriting was shaky. Every word was true. Raymond married Donna when he was 34. She was 31. He described their early years the way men of his generation describe the things that matter to them. Briefly, carefully, with no embellishment. They had 2 daughters, Cassidy, who was 15, and Layla, who was 12. Raymond coached Layla's soccer team every Saturday for 6 consecutive spring seasons. He never missed a game. He helped Cassidy with her AP chemistry homework every Sunday night, even when he didn't understand the material himself, because he believed that showing up mattered more than having all the answers. He had not missed a single mortgage payment in 17 years. He had not opened a personal credit card in 11 years. His finances were transparent, documented, and completely clean. When I read his file the night before the hearing, I set it down after the 2nd page, and I sat with it for a long time. Because the man described in those documents, steady, unglamorous, and profoundly present, was the same man Donna Hartwell was asking me to believe had failed his family. Donna Hartwell walked into my courtroom that morning like she had already won. She wore a cream blazer over a white silk blouse. Her bag was a Tory Burch Emerson in cognac leather, retail $498. Her heels were low, careful, calculated. She had been dressed to look respectable. She sat down at the defendant's table, crossed her ankles, and placed both hands flat in front of her. Composed, practiced. Her attorney was a man named Gerald Baines. Gerald Baines had been practicing family law in Cincinnati for 22 years. He was known for two things: his billable rate and his ability to shift a courtroom's emotional weight toward his client within the first 10 minutes of a hearing. He wore a charcoal Tom Ford suit. He set a leather portfolio on the table with the quiet confidence of a man who had never lost a case he'd chosen to take. He filed a motion the moment the session opened, a motion to exclude Raymond's evidence folder on the grounds that it had not been properly disclosed within the discovery window. I denied it in 18 seconds. Baines smiled, the small smile of a man recalibrating, not concerned, simply adjusting. The kind of man who is lost so rarely that even a small setback registers as a novelty rather than a threat. Donna glanced at Raymond's folder. Just once. Quickly. Then she looked away. That single glance, that is the detail I want you to hold on to. Because in a courtroom, in any room really, a person who is telling the truth does not look at a folder and look away. They look at it and they are curious. They look at it and they are unconcerned. They do not cut their eyes away from it like it is something hot. She knew what was in that folder. She had always known. That told me everything. Anyone who has watched me work knows what it means when I go still behind this bench. When my hands come together slowly, and the room around me goes very quiet. Someone is about to hear something they are not prepared for. I did not go still yet. I was watching. I was waiting for the moment she opened her mouth and asked me to believe her. She did not wait long. I asked Donna Hartwell one question before she had even finished her opening statement. I said, "You've described your husband as emotionally unavailable. I want you to look at me, not at your attorney, at me. And I want you to tell me one specific thing, one event, one evening, one moment that supports that claim." She did not hesitate. She had prepared for this. She told me about a birthday, Layla's 10th birthday party. She said Raymond had not come home in time. She said he missed the cake, missed the candles, missed the photographs. She described her daughter standing at the front window looking for his truck. She described herself telling Layla, "Daddy's busy, sweetheart." It was a good story. It was a specific story. It had the kind of detail that makes things feel real. The room believed her. I could feel it. I looked at Raymond. He hadn't moved. His hands were still folded on top of that folder. His face was completely still. Not cold. Still. The way a man is still when he has decided that the truth will speak for itself. I said, "Mr. Hartwell, would you like to respond?" He said, "Yes, Judge. May I show you something?" And the room went quiet. He opened the folder. He removed one photograph, just one. He walked it to my clerk, who brought it to me. It was Layla's 10th birthday party, taken at 6:47 p.m. in the backyard of the house they had shared. Raymond was in the photograph. He was kneeling behind the birthday cake with his arm around Layla's shoulder. She was mid-laugh. He was looking at her the way fathers look at their children when they think no one is watching, the way that costs nothing and means everything. Behind him, standing slightly to the left, was Donna. She was holding her phone. I set the photograph down on my bench. "Ms. Hartwell," I said, "I need you to look at this photograph and tell me what you see." She looked at it. Something moved behind her eyes, just for a moment. She said, "I don't remember that photo being taken." I said, "You know, the timestamp says 6:47 p.m. You testified he was not there." She said, "I must be misremembering the party." That is when I stood up. I do not do that often. In 38 years on this bench, I can count on one hand the moments when I have stood up, not in ceremony, not to leave the room, but simply to make someone understand, physically, that what they are about to hear matters. I walked around the bench. I stopped. I said, "Ma'am, you just testified under oath in front of this court that your husband missed your daughter's 10th birthday. You described your child standing at a window. You described yourself consoling her. That is a specific memory. Specific memories are either true or they are not. So I am going to ask you one more time, and I want you to be very careful with your answer, because the next thing you say in my courtroom will determine the character of everything that follows." The gallery did not move. Donna Hartwell looked at Gerald Baines. Gerald Baines looked at his portfolio. "Tell me," I said, How many other specific memories in your testimony today have the same quality as this one? She said nothing. Drop a comment right now and tell me, have you ever watched someone's lie collapse in real time? Tell me what that moment felt like. I read every single one. Raymond opened the folder again. He removed a second document. He passed it to my clerk without being asked. It was a grid, 17 pages. Date by date, event by event, every school play, every soccer game, every parent-teacher conference, every birthday, every holiday from 2011 through 2024, cross-referenced with GPS records from Raymond's phone, time-stamped receipts, and photographs. The man had not missed a single documented family event in 13 years of records. Not one. He had built that document himself. In the evenings, after work, after dinner, after putting Cassidy and Layla to bed. Over 4 months of quiet, careful, unremarkable evenings that no one had seen and no one had known about. That is the detail that stayed with me longest. Not the grid itself, but the evenings. The room was completely silent when I finished the first page. I said, "How long did this take you to prepare?" He said, "About 4 months, Judge. I did it in the evenings." Nobody in that gallery moved. Gerald Baines requested a recess. I denied it. We were not done. It was at that moment that the door to my courtroom opened. I do not permit interruptions during active proceedings. My bailiff moved immediately, and then he stopped, because the person who walked in was not a stranger. She was Cassidy Hartwell, 15 years old, Raymond and Donna's older daughter. She was in her school clothes. She had her backpack on. She had asked her school guidance counselor to bring her here, and her counselor, a woman named Mrs. Tara Nguyen, stood just inside the door with her hands folded, waiting to see whether I would allow it. I looked at Cassidy Hartwell for a long moment. She did not look at her mother. She looked at me. She was trying very hard to be steady. She wasn't quite making it. I said, "Counselor, bring her forward." Gerald Baines stood immediately. He objected on procedural grounds. He was precise, professional, and absolutely correct in the letter of his objection. I overruled him. There are moments in a courtroom where procedure and justice are not the same thing. I have learned in 38 years to know the difference. Cassidy Hartwell sat down in the witness chair. She set her backpack on the floor beside her feet. She folded her hands. She was shaking slightly. I said, "You don't have to be afraid here. This is a safe room. Take your time." She nodded once. She took one breath. She said, "I want to tell you what my dad actually did." And the certainty on Donna Hartwell's face didn't drain. It shattered. Like this video right now, if you believe that nobody is above the truth. Not in a marriage, not in a custody case, not in this courtroom. Every like sends this story to someone who needs to see it. Count with me, because what happened next took exactly 45 seconds. 45 seconds. And in those 45 seconds, every careful word, every practiced answer, every calculated expression Donna Hartwell had constructed across that morning came completely apart. Cassidy spoke for 45 seconds. She did not embellish. She did not perform. She said, "My dad came to every single one of my games. He never once made me feel like I was in the way. When I had surgery on my knee last year, he slept in the hospital chair for 2 nights because I was scared. My mom told him she would handle it. She told him to go home." She paused. He stayed anyway. Then she said one more thing. "I want to live with my dad. I'm 15. I think I'm allowed to say that." The courtroom was silent for a very long time. I returned to my bench. I asked Donna Hartwell one final question before my ruling. I asked her, "Is there anything you would like to say?" She opened her mouth. She closed it. She looked at Cassidy. And for the first time since she had walked into my courtroom that morning, Donna Hartwell looked like the person she actually was, and not the composed, practiced woman in the cream blazer, but a woman who had made a series of choices and was now, in this room, finally standing inside the full weight of them. She said, "I love my daughters." I said, "I believe you. That is not what is being questioned today." I straightened the folder on my bench. I looked at that photograph one more time. Layla, mid-laugh, Raymond's arm around her shoulder, the cake between them. And I thought about the man who had built a 17-page grid in his kitchen in the evenings after long work days, after putting his daughters to sleep, quietly, methodically, without knowing whether any of it would matter. I thought about what it takes to do that without bitterness, to gather evidence not as a weapon, but as a record, to trust, with no guarantee, that the truth would be enough. Then I delivered my ruling. Donna Hartwell's petition for exclusive home occupancy was denied. The marital home was ordered listed for sale with equity divided equitably following an independent financial audit. Her request for $4,200 per month in spousal support was denied in full, based on the documented pattern of Raymond's consistent financial contribution and the discovery of an undisclosed secondary income stream that Donna's own financial disclosure had omitted. The support petition was reversed entirely. Raymond was awarded primary residential custody of both daughters, with structured visitation for Donna 4 days per week, subject to judicial review in 6 months. Additionally, the court mandated the following. Donna was required to attend 12 sessions of family therapy with both daughters at a counselor of the court's designation. She was required to submit a corrected and complete financial disclosure within 30 days, subject to penalty for any further omissions, and a formal letter of acknowledgement, not quite an apology, but a documented recognition of the false testimony presented in this court, was to be prepared with her attorney and submitted to the court record within 60 days. I told her this directly. "Ms. Hartwell," I said, "I am not here to punish you. I am here to make things right for two girls who need both of their parents, and who deserve to see both of their parents behave with honesty, even when honesty is costly. The choices you made in this courtroom today will be part of your daughter's story. What you do next, but how you repair what today damaged, that is also part of their story. I am giving you the chance to make it a good one. Not to punish, to transform, because punishment ends when the sentence does. Transformation lasts." After I finished reading the ruling, something happened that I had not anticipated. Raymond Hartwell did not move for a long moment. He sat with his hands folded on that now empty folder, and he looked at his daughter. Cassidy crossed the room and put her arms around him. She was still shaking. He held on without saying a word. And in the third row of the gallery, a small woman with white hair rose slowly to her feet. I did not recognize her at first. She looked directly at Raymond, and she placed her hand over her heart. I found out afterward that it was Mrs. Eloise Pruitt, 84 years old. She had taken a taxi to the courthouse that morning, a 40-minute ride each way that she could not easily afford on a fixed income. She had sat in that gallery for 3 hours in a wooden pew with no cushion, on an arthritic hip, waiting for a ruling in a case that had nothing technically to do with her. She had not told anyone she was coming. She had not asked anyone's permission. She had simply decided that Raymond Hartwell deserved to have someone in that room who was there only for him. Share this video with someone who needs to know that quiet people, steady people, the ones who keep showing up without applause, without recognition, without anyone watching, they deserve to be seen. Post it. Because some stories deserve to travel farther than an algorithm can carry them alone. I did not return to my chambers immediately after the session. I stood at my bench for a moment while the room began to empty. My clerk, Sandra, who has worked beside me for 19 years, brought me a glass of water without being asked. She set it down without a word. I wrapped both hands around it, the weight of the morning released slowly, the way it always does when the right thing happened and you were in the room to ensure that it did. Donna Hartwell's false testimony triggered a formal court referral for perjury review, forwarded immediately to the Hamilton County District Attorney's Office. Senior Prosecutor Ellen Marsh cataloged the following counts: 1 count of perjury in a civil proceeding, 1 count of material misrepresentation under oath, 1 count of fraudulent omission on a court-mandated financial disclosure, 1 count of filing a misleading custody petition based on fabricated narrative, 1 count of conspiring to withhold documentary evidence prior to its scheduled disclosure, and 1 count of contempt for the introduction of demonstrably false testimony in a matter involving child custody. Gerald Baines withdrew from representation within 48 hours of the ruling. Donna retained new counsel. She did not contest the referral. Raymond came to my chambers that afternoon. He knocked twice. Sandra let him in. He stood just inside the doorway. He didn't want to take up too much space, even then. He said, "Thank you, Judge." I said 3 things. Your daughters are lucky. Not because you are perfect, because you are present. That is the thing they will carry with them for the rest of their lives. The knowledge that someone showed up when it was hard and stayed. Never underestimate what that means. He nodded. He was quiet for a long moment. Then he said, "I just want them to be okay." I said, "They already are, because of you." He left. I stood at my window for a while after the door closed. 6 months later, this is where things stood. Raymond Hartwell moved into a 3-bedroom rental 4 miles from the family home. Both daughters spent their weekdays with him. Cassidy was accepted to a summer STEM program at the University of Cincinnati. Raymond had helped her complete the application on a Sunday night in February, sitting beside her at the kitchen table, reading every requirement twice. Layla's soccer team won their regional division championship in the spring. Raymond was on the sideline for every single game. Mrs. Pruitt came to the championship. Raymond drove her himself. Donna Hartwell completed her 12 court-mandated family therapy sessions. She did not stop at 12. She continued voluntarily for 4 additional months. In notes shared in aggregate form with the court, she described for the first time, clearly, without deflection, the gap between the story she had told about her marriage and the marriage that had actually existed. She does not have an apology video. What she has is a Thursday evening dinner with her daughters, every week without exception, that she has not missed since August. That is not nothing. That is, in fact, a beginning. The perjury review resulted in a formal plea agreement. Donna received 18 months of probation, mandatory compliance auditing of her financial disclosures, and 200 hours of community service, which she is completing at a Cincinnati women's legal aid clinic, helping other women navigate the paperwork of family court. That was not my ruling. That was her choice. My mother used to say, "You cannot always choose the consequences of your mistakes, but you can always choose what you build from the rubble of them." The true measure of a person's character, she told me, is never the mistake itself. It is the reckoning that follows. She was right. She is always right. My mother came to this country from Cuba with $40, a suitcase, and a certainty so clear and so unshakable that I have never, in 38 years on this bench, been able to pretend I did not recognize it in the people who sit before me. She taught me that the difference between a person who has failed and a person who has failed without redemption is always, always, always a choice. A choice that belongs to the person who made the mistake, not to the judge, not to the court, not to the gallery watching. I can open the door, I cannot make anyone walk through it, but in the case of Raymond and Donna Hartwell and 2 daughters named Cassidy and Layla, the door opened. And both of their parents, in different ways and at different speeds, are walking through it. That is the best this courtroom can do. That is, in the end, the best any of us can do. If you believe in this kind of justice, and if you believe that steady people deserve loud advocacy, that quiet love deserves to be seen, and that the truth, when given a fair room and enough time, will always rise to the surface, subscribe to this channel. This community exists because of people who refuse to look away from the things that matter. And tell me in the comments, have you ever watched someone carry something heavy for a long time without complaint, without recognition, without a single person noticing? Tell me their name. Tell me what they carried. Let this community see them. And when you are done, look at the next video on your screen right now. It is about a decorated police chief who walked into my courtroom absolutely certain that his badge would protect him from what he had done, and walked out in handcuffs in front of the entire precinct that had once celebrated him. You will not see the ending coming. Justice isn't a hammer, it's a mirror. Court is adjourned.